And this morning we have two panels of witnesses. In the first hour, I would like to welcome our witnesses. We have from the Association of Manitoba Municipalities here in person, Catherine Valentino, the president. Thank you for being here. Online, we have from the Canadian Urban Transit Association, Michael Atlas is the honorary counsel. And also with us this morning from the National Police Federation's President Brian Sauvé. So welcome to the witnesses. Pleased you're being here. We're pleased you're here. This is a very important piece of legislation, which I know is the opinion of everybody in this room. And I should point out it's also the opinion of all of the premiers from across the country who on Friday issued a joint statement encouraging us to pass Bill C-14 expeditiously, to use their words. So I'm glad everybody is enthused about it. And in that vein, I just want to let the members know that on Wednesday we will be starting at 3:30, not 4:30, and we have resources for more than we should need, but until 1 in the morning, I'm told. Mr. Brock?
Mr. Chair, that could be problematic. I think we have 4 votes after QP.
It's subject to votes, of course.
Right. Okay.
Yeah, I mean, the reason we were starting 4:30 regularly was because of votes, so it may end up being that case. At 3:30, as soon as the votes are done, put it that way.
Will there be witnesses to start, or?
And we have 2 hours of witnesses to start Wednesday, and then we'll go right into clause by clause. So on that note, I will open the floor to the witnesses who have 5 minutes each for their opening statement, up to 5 minutes each for their opening statements. So I'll just start on my left, Mr. Sauvé.
Good morning, Chair and members of the committee. My name is Brian Sauvé. I'm a sergeant with the RCMP, but also president of the National Police Federation, the union representing nearly 20,000 members of the RCMP across Canada and internationally. Thank you for the opportunity to appear today to discuss Bill C-14. Our members see every day the impact that a small number of high-risk repeat violent offenders have on community safety. They also see the strain placed on victims, witnesses, and frontline police officers when those individuals are repeatedly released, breach their conditions, and quickly return to the streets. Bill C-14 is a meaningful step forward addressing this reality. The NPF supports the bill's clarification that public safety must be explicitly weighed in bail decisions. This aligns the law more closely with what police encounter on the ground. Individuals with lengthy criminal histories, repeated breaches of court orders, and escalating patterns of violence too often cycle through the system under conditions that prove ineffective or unenforceable. We also support the targeted expansion of reverse onus provisions for serious violent and weapons-related offenses. In clearly high-risk situations, it is reasonable and appropriate to require the accused to demonstrate why their release would not endanger the public. This change promotes greater consistency across the country and better reflects real-world risk. Additional measures in the bill, such as mandatory no weapons conditions for organized crime offenses and direction to consider whether an offense was random and unprovoked, further strengthen the public safety lens applied at bail. However, legislative reform on its own is not enough. Police officers are often the first decision makers in the bail process, making release or detention decisions shortly after arrest and frequently with incomplete information. The effectiveness of Bill C-14 will depend on whether police and courts have reliable, real-time access to an accused's outstanding charges, prior breaches, bail conditions, and patterns of violence across jurisdictions. National systems such as the Canadian Police and Information Centre are essential tools, but they were not designed to function as comprehensive real-time bail risk management platforms. Gaps or delays in data entry and sharing can lead to inappropriate releases and weaker bail positions before the courts. Modern, interoperable national information sharing is essential if the bill's public safety objectives are to be realized in practice. Stronger bail conditions must also be meaningfully enforced. Our members routinely rearrest the same individuals for repeated breaches, often with limited consequences. This cycle undermines public confidence and consumes significant police resources. Adequate supervision capacity, consistent breach enforcement, and clear feedback to police on court outcomes are critical. While provinces administer bail, federal leadership through coordination, funding, and national expectations can drive more consistent results. Finally, effective bail begins with effective investigations. Modern crime is increasingly digital. When police cannot lawfully and quickly access digital evidence, charges may not be laid, or critical information may be missing at bail hearings. Updating lawful access authorities is therefore a foundational public safety measure that complements the goals of this bill. In closing, the National Police Federation supports the central direction of Bill C-14 and its focus on protecting communities from repeat violent offending. Pairing these legislative reforms with modern information sharing, enforceable supervision, and lawful access to evidence, Canada can build a bail system that is fair, consistent, and genuinely protective of public safety. Thank you, Mr. Chair, and I look forward to any questions.
Thank you, Mr. Sauvé. Ms. Valentino.
Thank you very much, and thank you, everyone, for the opportunity to speak to you this morning. I'm Kathy Valentino, and first and foremost, I'm from the City of Thompson in northern Manitoba, next stop Churchill. I'm a city councillor there. We have the largest RCMP contract in the province of Manitoba. We're typically #1 in the Crime Severity Index. And I'm here today as the capacity of the President of the Association of Manitoba Municipalities, which represents all 137 municipalities across the province. The AMM is nonpartisan, and Manitoba municipalities are united in supporting legislation aimed at strengthening the public safety system and creating a far more effective justice system, because crime does not respect municipal boundaries or political lines. On behalf of the AMM, I wanted to attend in person to express my strong support for efforts to strengthen bail and sentencing provisions through Bill C-14. Across Manitoba, our residents are concerned about crime. Almost 9 in 10 support bail reform and criminal code changes to address repeat offending. 69% report being personally worried about crime. These concerns continue to grow as repeat offenders are frequently being released on bail. These risks are especially acute in Manitoba, which has among the highest violent crime rates in Canada. Municipalities have long warned about repeat prolific offenders being released on bail, and some recent tragedies underscore why. Last year, near the city of Portage la Prairie, Mayor Knox spoke publicly about a young woman who was tragically killed by an alleged impaired driver operating a stolen vehicle. At the time, the Manitoba RCMP had an arrest warrant for the accused for failing to comply with release conditions. More recently in Brandon, Manitoba's second largest city, Mayor Jeff Fawcett raised concerns after police responded to a machete assault near an elementary school, prompting a lockdown while the kids were on the playground. The accused was already under release conditions. And since 2021, breach and failure to comply charges in Brandon have increased by over 20%. Winnipeg has seen similar patterns. Mayor Scott Gillingham has pointed to an offender who, still just in his mid-20s, was convicted of 24 violent crimes over 11 years and violated bail or probation conditions 12 separate times. Taken together, these incidents underscore the need for strong reforms to deter crime and prioritize our public safety. Across Manitoba, our police are repeatedly arresting the same individuals, and frontline workers, including our firefighters, paramedics, transit, hospital, and bylaw staff, are regularly exposed to them. Being assaulted on the job is unacceptable, and it affects morale, retention, and service delivery. Bill C-14 must include strong protections for first responders, similar to those for peace officers. These include higher penalties for aggravated assaults against paramedics, firefighters, and other frontline staff. We strongly are welcoming the bill's aggravating factor provisions. More broadly, this isn't about detaining people without reason or locking people up and throwing away the key. It's about recognizing patterns, assessing risk, and putting public safety first. Municipalities welcome the acknowledgement that bail reform is necessary. Proposed measures such as expanded reverse onus provisions and stronger sentencing tools are critical to our community safety. Municipalities would also support broader measures to address repeat offending, including property and retail crimes. However, success will not be measured by this legislation alone. The effectiveness of Bill C-14 depends on sustained coordinating resourcing across the justice and public safety system in partnership with all orders of government, including adequate police visibility, including addressing Manitoba's RCMP vacancy rate, the highest in Canada, support for our first responders to focus on core duties, a court system capacity, including hiring sufficient Crown prosecutors to prevent backlogs and delays, and investments in mental health, addictions, and social supports to address these root causes of crime. Ultimately, all of us here, we want a justice system that instills public confidence, one that protects our communities while remaining fair and effective. You all here, the committee, you have the opportunity to move Bill C-14 forward promptly. Crime does not respect political boundaries, and addressing it requires cooperation across governments. In closing, I thank you for your time and attention, and I too look forward to taking any questions from the committee. Thank you.
Mrs. Valentino, thanks very much. Both of you are right on time, so which takes me to Mr. Atlas. You're online. You have the floor.
Good morning, Chair, Vice Chairs, and members of the committee. I am Michael Atlas, Honorary Counsel for the Canadian Urban Transit Association, CUTA, and I'm also General Counsel for the Toronto Transit Commission. I'd like to begin by thanking you for allowing us to appear before the Standing Committee on Justice and Human Rights. We cannot talk about national public safety without talking about safety on public transit. That is why I'm here today to ask you to amend the criminal code, and more particularly section 269.01, to protect all transit workers from assaults by expanding the current protections which currently only apply to transit operators. As the government seeks to build a stronger Canada by amending the criminal code, this is an opportunity to address a long-standing issue for transit workers. Public transit is a shared public space, and it often reflects broader societal challenges, including the mental health crisis, substance use, and economic hardships. Across Canada, transit workers are routinely on the front lines of these realities, and unfortunately, they experience violence and harassment while carrying out their essential duties of providing critical transportation and mobility to the communities they serve. These incidents are growing in severity, affecting employees across every part of the transit system, including operators, station staff, maintenance workers, fare enforcement personnel, customer service agents, and transit security. For example, in 2025, assaults against TTC employees rose to a high of 40 incidents in one single month. That is 40 employees who may be your friends, family members, who left home, came to work, and were assaulted just for doing their job. With the support of the City of Toronto and the Province of Ontario, TTC has been making investments in safety by expanding frontline presence, partnering to launch the Toronto Police Services Neighborhood Community Officer Program, increasing visibility in stations, and more. We've seen the impact of these investments as customers' feelings of personal safety have risen to 62%, which is a 6-point increase from the previous year. However, assaults against transit workers continue to be a serious issue, impacting the well-being of our essential transit workers, not just in Toronto, but across the country. One assault against a transit employee is one too many. In response, the Canadian Urban Transit Association established a Transit Safety Task Force to examine the root cause of violence on transit and identify practical solutions. In 2023, the task force released a comprehensive set of recommendations focused on strengthening safety measures, improving incident responses, supporting workers after traumatic events, and working with governments and community partners to address broader societal factors. A key finding from this work is the need for clear legal recognition and protection for all transit workers. Currently, under Section 269.01 of the Criminal Code, assaults or threats against transit operators are treated as an aggravating factor at sentencing. However, this protection applies very narrowly, limited only to vehicle operators directly employed in driving a bus, train, or other transit vehicle. It does not extend to the many other frontline transit employees who interact with the public daily and face similarly risks of assault. Our ask is very simple. Expand Section 269.01 to include all transit workers who, in the performance of their duties, and not limit its application just to transit operators. In May 2024, Member of Parliament Bardash Chagar introduced Bill C-395, which passed first reading, but unfortunately did not advance further. The bill proposed a targeted amendment to Section 269.01 to strengthen sentencing provision for assaults or threats against all transit workers. This change, replacing the term transit operator with transit workers, is simple but significant. It would ensure that all transit workers, not only vehicle operators, are formally recognized as facing elevated risk while performing their essential public duties. All transit workers play a vital role in ensuring the safety of customers and making customers feel safe. They are often the first on the scene during assaults, medical emergencies, and other crises. They protect passengers, they de-escalate volatile situations, and they call for assistance. Assaults against transit workers have serious physical and psychological impacts. They contribute to burnout and make it more difficult for transit agencies to recruit and retain workers. Other frontline public workers receive explicit legal recognition when assaulted in the course of their duties. Transit workers face comparable risks, yet the criminal code does not consistently reflect that reality. This issue has received broad political support, with members from both government and the opposition recognizing the importance of protecting transit workers. Safe public transit is essential to our economy, our communities, and our climate objectives, and it depends on a workforce that feels safe and supported. There's also strong support from transit unions, including the Amalgamated Transit Union. Workers have been clear. Legal clarity matters. Explicit recognition of their role and the risks they face reinforce that violence against them will be treated with seriousness it deserves. Ultimately, this amendment is more than sentencing. It is about confidence. Transit workers need to know that the law is on their side before an incident occurs. We encourage the government to take this opportunity to protect workers, because when transit workers are safe, Canadians are safe. In closing, an amendment to Bill C-14 that would extend Section 269.01 protections to all transit workers would be practical and a measured step towards improving transit worker safety. It reflects the lived experience of workers across Canada and would strengthen public transit systems nationwide. Thank you, and again, I would be pleased to take any questions.
Thank you, Mr. Atlas. Okay, we'll go to start with the 6-minute round, beginning with Mr. Brock.
This is for your attendance today. Mr. Sauve, C-14 is marketed by this government as a bundle of sweeping reforms. In reality, Canada and law enforcement are not getting this. The bill's stated objective is to make stricter bail laws and address violent and repeat offending and organized crime, and tougher sentencing laws for serious and violent crimes. This must be a deja vu moment for you, Mr. Sauve. As you recall, this was the exact messaging we heard from Justin Trudeau and David Lametti, our former Justice Minister, on the passage of Bill C-48. Both promised Canadians and law enforcement that they were listening, and adding more reverse onus charges to serious criminal offenses would lead to a greater number of violent repeat offenders being detained. The explosion of criminality over the last 3 years proves this government's approach was wrong. Although you are on record of being supportive of C-48 as being a positive first step, are you now guarded with C-14's addition of more reverse onus provisions to criminal charges?
Not at all guarded. First step leads to second step, which hopefully leads to third step. And I think we're also on record about talking about how when you talk about bail and the administration of justice, it is a partnership.
Would you agree with me on 48, there was no second and third step by this government?
Well, what I'm suggesting is here we are at the second step.
A second attempt, maybe even a third attempt at bail reform. Started with the disastrous addition of the principle of restraint in Bill C-75. C-48 was a failure. Let's hope 14 brings necessary changes to law enforcement and Canadians. Regarding bail, 14 attempts to diffuse outrage for the principle of restraint that requires judges to release the accused at the earliest opportunity on the least restrictive conditions. It adds a line to clarify the principle does not require the accused to be released. Do you agree that Canadian judges already know that principle?
I think you would have to ask judges about that question, and I'm just a cop.
Over 50 pages long, C-14 only addresses a sentence increase to one criminal offense. Over the course of 10 years, violent crime is up 55%, firearm crime up 130%, and sexual assaults up 75%, to name a few. Yet this tone-deaf government saw fit to increase the penalty for contempt of court from 6 months to 2 years less 1 day. Contempt of court is the refusal of a witness under subpoena to attend court to give evidence. In your decade-long career in policing, how many contempt of court investigations were you involved in?
Personally,
Yes.
I haven't been involved in a contempt of court. Yep.
0. And I've got almost 20 years of crowning in the Ontario criminal justice system, and I had 0 prosecutions. Extortion is one of the fastest growing crimes in Canada and is spreading fear across this country. The data is clear. Since the Liberals took office, extortion has surged by more than 330% nationwide. In BC alone, extortion is up 582%. In Surrey, their mayor is asking this government to declare a national state of emergency. That city is under siege. Its citizens are terrified, yet 14 only mentions extortion once. That extortion convictions are to be served consecutively to arson arising from the same event. Do you think this government should have introduced mandatory minimum penalties to this rising crime?
I think from my experience, from what I've seen in my 20 or so years in policing, mandatory minimums haven't worked.
Believe then to increase the significant penalty for extortion that's currently in the code would be a proper step instead of contempt of court?
Well, I thought we were here to talk about bail reform. But
it's not just bail reform, it's the bail and sentencing reform package. That's the title of C-14. If you don't want to opine on that, officer, that's fine. Or sorry, Mr. Sauvé. Do you think the government missed the mark in not legislating in C-14 consecutive sentences for child sexual offenders?
When we talk about consecutive sentences, again, I would love to see consecutive sentences. As you know, Justin Bourque was the recipient of consecutive sentences which were overturned to be concurrent sentences not less than a year and a half ago. So I think in that perspective, I would prefer to see consecutive sentencing for egregious crimes.
Do you think the government missed the mark in not legislating in C-14 any pushback against the Supreme Court of Canada's odious ruling that consecutive periods of parole ineligibility constitute cruel and unusual treatment for those convicted of a number of first-degree convictions?
Parole eligibility and ineligibility, I think, is a broad topic, and we're actually on record about talking about mandatory parole and the Conditional Sentencing Release Act and how that should be looked at and modified, and perhaps Canadians would feel safer if they knew that offenders, especially violent offenders, were mandated to spend their entire sentence behind bars versus being eligible in 66% of the time.
Thank you, Mr. Sauvé.
Thank you, Mr. Brock. Ms. Latanzio.
Thank you, Mr. Chair, and thank you to the witnesses for taking the time to be with us this morning and helping us do our work on this very important piece of legislation. My first questions will be directed to you, Ms. Valentino. You've spoken in support of targeted and workable reforms. From a municipal perspective, how important is it that Parliament focus on measures like clearer direction and bail direction and expansive reverse onus for repeat violent offenders rather than the broad changes that may sound tough but don't deliver on the ground?
For Manitoba municipalities in particular, that's very important because we want the strength to the reverse onus to happen because we're seeing more and more that it's the repeat offenders that are continually getting out quicker and creating crime in our communities. So I think that that's important for Manitoba municipalities, that that's a part of the bill that's looked at, absolutely. And you have to work in partnership with the provincial government also to ensure that it works downwards to the municipalities through the province also.
We've got that loud and clear that it's a collaborative work between federal, provincial, and municipal governance. Some critics argue that C14 does not go far enough. Based on your experience representing local governments, how do you respond to the claims that this legislation is limited to make a real difference in our communities across the country?
Bill C14 is far more than what we have now, so it will definitely make a difference in our communities in Manitoba.
Okay. Municipal leaders such as yourself are responsible for community safety but do not control criminal law. So how does Bill C14 help give municipalities greater confidence that repeat and violent offenders will be dealt with more effectively by the justice system?
Because we feel that it will free up our RCMP so that they'll have more boots on the ground and a presence in our communities and start to do more proactive policing, working in partnership with municipalities with some of the programming that municipalities are paying for and doing, as such as community safety officers and programs. So it will definitely make a difference in our municipalities for sure.
And in your opinion, how does Bill C14 strike the right balance between strengthening accountability for serious offenses and ensuring that decisions remain fair, practical, and legally sound?
I'm not in the justice system, so I can't say how that would work parallel, but I know for municipalities, we feel that Bill C14 is in the right direction moving forward, and the data and what comes of it we will see, and the difference in crime in our streets we'll be able to see how it's working.
And what would you say to Parliament about the importance of moving Bill C14 through committee efficiently so municipalities and communities can see these changes implemented without unnecessary delays?
We want the committee to move this bill forward very promptly and very quickly. And some of the real-life examples that I've spoken to, we're actually seeing, innocent people that are now dying because of repeat offenders getting out quickly. So it will make a difference, and it can make a difference quickly, and lives will be saved if we can move this bill forward to make our streets safer, especially in Manitoba that I'm speaking for.
Thank you. Mr. Sauvé, over to you. So in your opening remarks, you spoke about resources. So Bill C14 is one step to a broader public safety solution. You have also spoken about the need for better coordination and resources. Can you explain why it is important that provinces and territories also play their role in implementing these reforms and supporting police?
Certainly, and I'll use just one simple example. I was in New Brunswick a couple of months ago, and their pretrial detention facilities are running at 153% vacancy. So a judge, a judicial justice of the peace, a Crown, will have to take that in consideration as they think about bail and sending someone, maintaining someone in custody or releasing them on bail. Not enough places to put offenders pre-trial. So that's a provincial investment, a requirement for a provincial investment, but also, it could be a federal leadership thing where you guys take the ball and you start running with it.
You have identified the need for better data sharing and monitoring of accused on release. In this context, how important are the bail and sentencing changes that we see now in Bill C14 to improve outcomes for both victims and frontline officers when coupled with these supports or these suggested supports?
Well, we're not at the information sharing stage yet, right? So there's some form of real-time cross-jurisdictional, and as my fellow witness here mentioned, crime does not respect municipal or provincial boundaries, and having court systems that don't talk to each other between Manitoba and Alberta, where a police officer in Calgary or a police officer in Winnipeg cannot see what court provisions or what court enforcements or what bail provisions have been stayed or are still outstanding, that has an impact on crimes that are committed in cross-jurisdictional areas.
And finally to you, Mr. Sauvé, finally, what would you say to this committee about the urgency of moving Bill C14 forward so that police services can begin using these updated tools immediately and communities can see improved safety without unnecessary delays?
Short answer, please.
I think it's urgent that you get it done.
Thank you.
Thank you. Mr. Fortin.
Thank you, Chair. Mr. Sauvé, Ms. Valentino, welcome to our committee. Thank you for being with us. Mr. Sauvé, My colleague, Ms. Latanzio, asked you a number of questions, and I heard I was going to ask you those, so I've gained a bit of time, but I'll go a bit further on those. As a police officer, I think that the members of your federation must understandably be frustrated seeing the same offenders being arrested for similar crimes. And we need to fight against repeat offending. I think C-14 is a step in the right direction. Can we do any better? We always can. But I do think it is a good step in the right direction. In an ideal world, we wouldn't put everyone into prison. There would be no one in prison. In an ideal world, when someone commits a crime, we succeed in rehabilitating that person, make them understand what should be done. So do you agree with me in saying that the final objective should be that people who have committed offensive should not repeat offend? I would suspect that the answer is yes. And if that is your answer, I would ask you, what are the most urgent measures that need to be put in place to rehabilitate these individuals committing offenses? Thank you for the question. That's a good question. I'll answer both in English and French.
Canadian legal system, the Canadian justice system, is built on the foundational principle of rehabilitation, not incarceration. So with that being said, where are we failing in that system? So, for example, post-sentence in custody, whether it be provincial or federal custody, are we actually investing in rehabilitation of those offenders? Are we preparing them for a productive life once on parole or once completed their sentence? That I haven't seen. We haven't seen investments within for, a vocational training program, housing assistance program on post-sentence release or on probation post-sentence. So can we do better there for those who are incarcerated? Yes.
And I'll ask you this question in French, but please feel fully free to answer in English. But which measures exactly? Because when people are incarcerated after receiving a sentence, unless I'm mistaken, I think there is a program that's triggered to work with reintegrating them into society, to help them learn job training, etc. But when they're in pretrial custody, the way I understand it is that there is no rehabilitation program. And also, I see that these people are very numerous, and they are in pretrial custody for long lengths of time. I think that another witness told us that there were 75% of people held in provincial prisons have never been convicted of a crime. It is all pretrial detainees. So I would ask you, doesn't that speak to a problem in our justice system? So what can we do specifically? You are working with these individuals day in and day out. So they have a trial and they're convicted, and then after a few months or years, they reoffend. I'm sure you have much more expertise than I in this domain. So what should we do with these people? How should we act to prevent reoffending? That's interesting. And I really think that is a question for a lawyer. But I will give my opinion.
Awaiting conviction. Est-ce qu'on a le droit de te mettre dans un centre de formation pour une vocation? Convicted, le juge il peut donner des.
The judge can intervene to trigger job training, etc. So I really do think this is a question for a lawyer, if it is possible to do that before a conviction.
Right, so that's my perspective on that, but I don't know if I'm right.
Je vous remercie.
Thank you. That is an excellent point. That issue can be complicated. So if they are acquitted, of course, there's no problem. It means that they would not have committed the crime, or at least in theory, they would not have committed the crime they were accused of. But if they are convicted, they will have to fulfill a sentence. And there are other problems. involved in calculating the length of that sentence, and we could come back to that. But anyway, they're convicted, and they have carried out part of their sentence before and then after the conviction. So if they have 2 years of sentence to serve, shouldn't there be a rehabilitation process put in place? And if so, do you have any idea regarding that? You were a police officer and you've worked with these individuals. So in your opinion, is there something that should be done for that? Well, there are provinces and territories currently that are considering doing mandatory treatments to put them into mandatory treatment. So that is a rule and a budget that is under provincial jurisdiction. It's a decision for provincial and territorial governments. But if the federal government could intervene, that would always be good. Thank you, Mr. Fortin.
We'll move into the second round for 5 minutes each. Mr. Lawton, starting with you.
Thank you very much, witnesses. And Mr. Sauvé, it's good to have you back again. People may recall you testified as a witness before our study on bail, which the Conservative team initiated, understanding the urgency of this issue. And I'm very grateful not just to have you and your other fellow witnesses here today, but also that our Liberal colleagues have allowed us to finally get to work on reforms that you and other police have been calling for across the country for many years now. I want to return to C-48. Because you were, and the federation you represent, were very, very optimistic on C-48. But when you testified earlier before this committee in September, one of my Liberal colleagues had asked you how C-48 had improved the safety of victims and the safety of officers on the front line, and you said, quote, "I don't think they have." So we have had false starts before. If we are to take our cues from your experience in this regard, how can we make sure that this bill, C-14, is not retreading old ground in that sense? How can we make sure that this is actually living up to the promises?
That's the challenge, and whether it's C-75, C-48, or C-14, and we've said in numerous submissions as well as numerous pieces of testimony that, this justice system, when you're talking about bail or you're talking about sentencing, it's a joint partnership. The federal government can lead and govern with respect to the criminal code, but your provinces and territories administer. And without their joint partnership and funding for adequate Crown attorneys, adequate judges, adequate pretrial detention facilities, adequate probation officers, adequate resources to administer, then we're setting ourselves up to fail, regardless of what system we put in place in the code.
Recognizing that, sadly, in my role, I can only deal with the issues that are in federal jurisdiction, in this context, the code, you indicated that you view C-14 as a second step, but you suggested in your earlier response to Mr. Brock that there should be a third step beyond that. So if we are to get this right, what should be in the bill that's not in the bill? What would you like to see building off of this?
Well, when I speak about a third step, so if we're talking about first step, C-48 now, or C-14, second step, if you recall I think it was in November when we were studying the bill, right, one of the recommendations or one of the pieces that we put forward is, can the federal government be a leader in consistent training for judicial justices of the peace, or consistent training in application of C-14 or C-48 or reverse onus provisions, so that you have consistency across the board in provincial court systems. You could convene a meeting of, instead of a first minister's meeting, you convene a first attorney general's meeting, so that there is consistency across the board, and every police officer and every court across the land is actually operating from the same premise.
The NPF has previously recommended ensuring that bail hearings are only presided over by justices of the peace that have legal background. Is that something that you would like to have seen in C-14, and perhaps something that could be included as an amendment in the criminal code that you would welcome?
I think that's something that would be welcome. Whether it can be done and whether it would withstand scrutiny is the other question. But I think, consistency, whether it's JJPs or only judges or only JJPs, or whether they are folks who are consistently trained to the same standard across all jurisdictions, would be a welcome.
I've heard anecdotally from officers that I've spoken to in my riding that they do see a very clear connection between the really bad bail decisions that we hear about that often make the news and cases that were presided over by JPs rather than judges. Is that consistent with your experience as well?
But it's also who's arguing the case on behalf of the Crown. So, for example, as a police officer, in some cases, I was arguing the case and writing the case for the primary, the secondary, and the tertiary grounds. So, you know, in that case, like, let's have some consistency across the board. Should it be police officers in some cases that are acting on behalf of the Crown, or do we need more resources so we have consistent arguments that are going forward to consistently trained JJPs or judges at hearings?
In the Conservatives' Jail Not Bail Act, which we had hoped to receive collaboration on from the Liberals, we had urged, listening to concerns that have been raised by police, the removal of the ability for people who are themselves convicted of serious offenses vouching for people as sureties. Is that something that you would support including?
Again, it's an interesting topic to explore. I don't know whether it would withstand scrutiny.
But would you support it if it did?
I'd have to look a little bit more into that one. Yeah.
Thank you.
Thanks, Mr. Lawton. Okay, over to Mr. Chang for 5 minutes.
So my first question would be directed to Mr. Sauvé. From your perspective, where do you believe Bill C-14's bail reforms address the real gaps, and how do they align with what police have been asking for?
Well, to start, I think the clarity around reverse onus provisions and placing a lot of reverse onus on those accused of more serious and perhaps random and unprovoked attacks to actually declare why they are worthy of bail. That's a start. And then you have some challenges, or not challenges, but good pieces, again, to start with when you're talking about organized crime and mandatory firearms bans and mandatory those. So the challenge is going to be from a law enforcement perspective is when someone does achieve a reverse onus provision and is released on bail on their own recognizance or some form, and a police officer finds them violating it, what happens then? And are we going to end up in the same situation we have today where courts or crowns are not taking breaches of bail provisions as seriously as other offenses? So, you know, is it your second strike? Is it your third strike when we are going to deny you bail? So those are all good starts, but, you know, the devil's in the details and the proof's in the pudding.
Okay. Thank you. And you have stressed the importance of ensuring courts have the tools to keep repeat and violent offenders off the street. How do you see Bill C-14 strengthening public safety and community confidence in bail decisions compared to the current framework or current system?
Well, as just mentioned, right, you know, you are expanding and strengthening the opportunity for reverse onus provisions. And when you talk about repeat violent offenders, that's who it's going to impact. And those are the ones that are going to be seeing a more difficult road to achieve bail than just your average everyday first offender.
Final question to you is that would you urge all parties to pass this Bill C-14 as soon as possible to protect Canadians?
I would.
Thank you. So my next question goes to Mr. Atlas. Looking specifically at the bill's bail reform for repeat and violent offenses, can you acknowledge how these changes strengthen the ability of court to better manage risks in communities, including transit systems?
So really, the suggested change that we're talking about is really just for transit workers, and to try to make sure that the criminal code recognizes transit workers in the same way that they recognize transit operators. But to answer your question, I don't speak for CUDA on this issue, as it's outside the bounds of CUDA, but myself, I would agree that it does help municipalities.
Thank you. You represent transit agencies that work closely with municipal and provincial partners. How important is it that provinces and local governments play their part in enforcement, support, and implementation rather than expecting the federal bail reform alone to solve all complex transit safety issues?
So it's critical. This is about a multidisciplinary approach. So it takes everyone to assist in ensuring that you have a safe public transit system, all levels of government and enforcement, as well as criminal code amendments.
Okay. And my final question to you is that would you agree that moving forward with targeted workable reforms like those in Bill C-14 is preferable to delaying actions in pursuit of broader changes that may sound tougher but risk not delivering real improvement for trans workers?
I would.
You urge all parties to pass this Bill C-14 as soon as possible?
Yes.
Thank you. And my final question goes to Ms. Valentino. So municipalities are often on the front line when it comes to impact of repeat and violent crime. Can you explain why the Association of Manitoba Municipalities publicly welcomed Bill C-14 and why this bill and sentencing reforms matter for community safety?
Thanks for the question. So we're hearing first and foremost from residents on our Manitoba municipalities, and AMM researched a survey, and it was clear that 9 out of 10 of our public is feeling unsafe. So we support this wholeheartedly because we see these repeat offenders repeatedly doing the crime in our communities. And as stated before, our RCMP and our frontline workers are all being subject to these repeat offenders. And if we can not have them, if there are stronger conditions for them, if they're a repeat offender to not get out, then we'll be able to have more resources, boots on the ground with our RCMP to keep our municipalities safer, because the feeling right now is that our streets are unsafe because of the repeat offenders.
Thank you very much. Okay, so we have about 7 minutes left, so I'm going to give Mr. Fortin his 2.5 minutes, and then I'm going to give Mr. Barber and Ms. Dillon 3 minutes each.
Merci, Monsieur le Président.
Thank you, Chair. Mr. Sauvé, in your witness testimony earlier, you talked about how important it is to have enough information for police officers in their work. As far as you know, do statistics or numbers currently exist on repeat offending for people who are released on bail versus people who were convicted and then served a sentence? Yes and no. It depends. For example, if you're in the city of Montreal and we're talking about someone who is a repeat offender, you have all the information locally. But if you change a jurisdiction, it can become problematic between Quebec and Ontario or between different provinces. So it's a problem of exchanging information. So it would be important to have a program in place that would make it possible to transfer this information. Yes, absolutely. Thank you. Ms. Valentino, I don't want to blame you in any way, so please don't take it that way, but municipalities in Manitoba, Quebec, and everywhere equally are faced with these cases of violence and repeat offending. I was chatting with Mr. Sauvé about it earlier, about the importance of constructive and effective rehabilitation for offenders. Unfortunately, it's not always available. We just have a few seconds left, but in your opinion, what can be done where there is not enough investment in this rehabilitation above and beyond funding? Are there other reasons for why that is happening?
Sure. So I think that it speaks to it clearly that it takes all orders of government that have to make this work and have a little bit of skin in the game. So the federal government, the provincial governments, and then the municipalities also. If we're talking about some kind of reform or programs, municipalities are already doing that on their own and on their own dime for their taxpayers. They're creating programs in their communities to try and, get at-risk youth to do low-cost recreation things. So they're already trying programs of rehabilitation for criminals and for keeping their streets safe.
Thank you. And quickly, can you talk to us about crimes committed by adolescents, by teenagers in your region?
Mr. Fortin, we're out of time, unfortunately. I'm sorry.
We need time for translation, Mr. Chair.
I know. I've given you a little bit of extra time.
Thank
actually,
you.
But yeah.
Merci.
Fortunately, I don't make the rules. I just have the unfortunate, unenviable task of enforcing them. So, okay. So
I understand.
3 minutes, and then Ms. Dillon for 3 minutes.
Ms. Schwartz, we'll try and go quick. Mr. Atlas, welcome. I understand you are legal counsel for the Toronto Transit Commission.
That is correct.
I got into provincial politics about a decade ago because I'm very passionate about the TTC. It's been my lifetime work to try and connect Shepherd West Subway Station and the Shepherd Yonge Subway Station, which crosses through my riding of York Centre and the great riding of Willowdale. I certainly hope that maybe you can try and assist me with that.
I am also a member of that same riding.
I'm honored to represent you. Mr. Atlas, I noticed a CBC article from November 26, 2025, that says that in the last decade, physical assaults are up 160% on the TTC, and all violent crime is up 127%. That's notably since the year 2015. Does that sound right?
So I don't know the numbers, but yes, it's definitely increased.
I can think of something that happened at 2015, that is the election of this present Liberal government, but is there another reason why do you believe that we see such an uptick of violence on the TTC?
I don't know if I have an answer for that. I think when you look at how we're trying to solve the problem, you're looking at it through multiple different approaches. You're looking at mental health crisis, you're looking at substance abuse, and you're looking at homelessness. And so the way, at least from a TTC standpoint, is we're looking at all of those disciplines, and I don't know if there's one reason over another of why you've seen it.
I used to take the subway to work every day, both when I worked downtown and when I worked at Queen's Park. But unfortunately, because of all the incidents, the subway is just simply no longer reliable in the city of Toronto. I did look at the mental health component. According to the Toronto Sun, 1 out of every 4 incidents where a person is involved is due to a mental health issue. To your knowledge, is that addressed in Bill C-14?
I'm not aware of that being addressed.
Not addressed. I want to ask you about special constables. How is that working out, or do you believe that they need greater law enforcement ability, or they need to be armed, perhaps?
No, I personally don't think they need to be armed. I think special constables do a great job of providing safe and secure transit system. So I don't necessarily think they need to be carry weapons.
It's very sad to me that in the city of Toronto, parents no longer feel safe for their children to take the TTC on their own. I think the TTC is such a landmark in our city, and it's very, very sad that we're here today. And I also note that primarily the mental health component of this has gone up after the pandemic response. Is that correct?
That would be, I think that's the perception, yes. I just want to reiterate that the TTC remains a safe system, so you can encourage your friends' kids to continue to take TTC.
Thank you, Mr. Baber. Ms. Dillon, over to you for 3 minutes.
Thank you, Mr. Chair. I will start with Mr. Sauvé. Thank you for your testimony, Mr. Sauvé. You were being questioned about your experience as a police officer, as an officer, and you said something interesting. You said in your experience, you did not see mandatory minimum sentences as being a deterrent. Can you please expand a little bit on that? Thank you.
Yeah, I'm not against mandatory minimum sentencing, and I think most police officers are not against mandatory minimum sentencing. My experience has been it's very difficult at trial or with a Crown to proceed and make the argument for a mandatory minimum sentencing or for a judge to award a mandatory minimum sentence. So that's been my experience. We've tried on a number of occasions and haven't been successful. It's an extremely uphill battle.
And you said that you spoke about data gathering and sharing. Can you talk to us a little bit about what you would see more helpful to prevent restrictive territorial jurisdictions? Because you've mentioned a few times that it's very important that there's a collaborative effort across Canada. If you can talk to us about that.
If we just talk about one jurisdiction, so for example, all of my experience in the Lower Mainland of British Columbia, so the BC court system operates on one software platform, which is fine. And we arrest someone for break and enter. They are released on bail because it's a first offense. Over the next several weeks before their court appearance, they violate that bail or they breach their conditions for whatever reason. So by the time they deal with the substantive offense of break and enter, which might lead to a guilty plea in exchange for a stay of proceedings on the numerous breach of bail violations, all a police officer is going to see on a next offense or the next time someone commits a crime is the conviction for the break and enter. They won't see the fact that they were charged and had stays of proceedings on the numerous bail violations. And it gets even more compounded if you change jurisdictions or if you change provinces. So a Crown Counsel in Lethbridge, Alberta may appreciate knowing that someone who's been arrested for break and enter has a conviction for break and enter, but also has 17 stayed charges for bail violations in a different jurisdiction or a different province. That might change their argument on bail, and it might change a JJP's decision-making process on granting bail.
Perfect. And as we've seen, reverse onus is also something that is going to be expanded when it comes to there's intimate partner violence and, for example, auto theft, violent auto theft. You would like to see, I'm sure, this bill quickly passed for these reasons. I would.
Let's get step 2 over with and move on to step 3 and get all jurisdictions working together.
Thank you, Ms. Dillon. We're going to have to stop there. I just want to say thank you to all 3 of the witnesses, not only for being here today, but for your service. We're all incredibly grateful. And I will take issue with only one thing that was said and that was Mr. Sauvé. You said, I'm just a cop. You're not just a cop, sir. You're a police officer. And we all owe you a debt of gratitude, as with all of your colleagues. So thank you all for being here. We'll suspend for a moment. We'll get the next panel ready.